Okay, let me know when we're live.
Not yet. It's coming on.
Okay.
All right, you live.
Good afternoon, everybody. This is Delegate Charlotte Crutchfield, and I'm the chair of the Subcommittee on Family Law and Juvenile Law. And we have our subcommittee meeting today, March 11th, and it is 2:49. We're going to start out with just going back. Good afternoon, everybody. This is Delegate Charlotte Crutchfield. Oh, somebody's got something on. Okay, thank you. All right, so we're going to start out with Bill HB 823, which is a bill we took up on Monday, and we just needed to possibly ask a few more questions and then determine what we're going to do next with the bill. Okay, so for questions, we have Gray Barton and we have Krista Williams. And did anybody have any other questions that they wanted to present to the advocates here? And if not, and I don't see any questions, I really wanted to make sure that I understood the data involved. Gray, do you all actually have data on how effective the truancy programs have been, the pilot programs that have been in existence?
Thank you for having me. We currently, so the annual reports that we do right now, we collect from the trial courts. We collect information on who has been, how many have been admitted, how many have been discharged, successfully completed, and then the total number served is what we currently collect. Okay.
All right. And then I guess I was a little concerned about whether DJS was really involved with this. And I didn't really get a strong answer on that. So that's sort of a concern I have. The other thing is, I know currently in the pilot process, other jurisdictions can actually do this. They can actually, actually create and expand programs in other jurisdictions. So I guess I just wanted to make sure I understood really the benefit of this legislation, because all it sounds like it's really doing is taking away the pilot, but you can already do a pilot in any jurisdiction already. So I guess I just want to make sure I'm clearly understanding all the pieces here.
Currently, except for those that are currently designated, so all in the First Circuit, that's Dorchester, Somerset, Wycomico, Worcester. We also have Kent County, Harford County, and Prince George's County. Only those can operate a problem-solving court, truancy court. So a court, a truancy court that's through the court system that is designated as a problem-solving court. Without this legislation change, we'd have to do what we did with everyone except for the First Circuit, where they've had to come back and have this modified to allow them to work. So and could you repeat again, Gray, those all the listed jurisdictions currently? Sure will. First Circuit, which is made up of Dorchester County, Somerset County, Wycomico, and Worcester County. And then we also have Kent County with the program, Harford County, and Prince George's County that has truancy courts, court-involved programs.
All right. And I understand that Sarah is in the waiting room if you'll let her in. Okay. Jeremiah, Sarah's in the, got it. Okay, so those are the current ones. All right. As I mentioned, I'm a little concerned about just the, that there's not, it doesn't sound like the partnership that I was expecting for DJS to be able to provide, sort of that hookup of diversion programs doesn't seem to be clear. And I wanted to go back to them and talk to them a little bit about that. But anyway, Delegate Shetty has a question. Go ahead, Delegate Shetty.
Thank you, Madam Chair, and thank you, advocates, for joining us today. So I think for me, where my challenge is that I feel like these programs bring in potentially unnecessary early court involvement for young people. And I'm having trouble grappling with that because I feel like often in the case of absence from school, in many instances, there are other root causes there. And I don't know necessarily that I feel convinced that the court is the best equipped place to get at some of those root cause issues. So for example, if the child is experiencing housing insecurity or lacks clean clothes or has a parent with mental health issues at home or any number of things, getting the child into the system to me doesn't really address any of those underlying issues. And I would rather see us working on true diversionary programs otherwise. And so I'm just curious if, so right now the pilot program operates in a kind of small number of jurisdictions, as I understand it. So the data you have is from those jurisdictions, which, are also happen to be not particularly diverse jurisdictions in our state. I mean, so I'm just curious if you can share in other jurisdictions, particularly those that are more diverse and where you have large school systems, like Montgomery County, Prince George's County, Baltimore City, these school systems are larger, more diverse, and the children are experiencing a variety of different issues. If you could speak to what programs currently exist in those larger jurisdictions to address some of those root cause issues of truancy, and, I'd just be curious to know what's broken in those jurisdictions. Like, how does what you're proposing fix or address something that may be lacking in these other jurisdictions? Thank you.
Yeah, thank you. No, very good points. And again, this is one of those where, truancy courts, I will not say that this is the only answer and the end all answer. There are many interventions that should happen and many times do happen prior to the truancy court intervention. So that could mean, from the school itself, having interactions with pupil placement workers and or counselors. It goes on to, dealings with the Department of Juvenile Services or any other type of interventions, all the way up to, and really this is, and many of our problem-solving courts really are the last intervention or the farthest intervention away. And we hope that we support, we actually, we meaning the Maryland Judiciary, support another truancy initiative in Baltimore City that Ms. Williams talked about last week, earlier this week. We're very supportive of those. So the truancy courts themselves are one of many interventions, we do, and when we have our interventions, we also do, there are family assessments that are completed on each student and their families as they come in. And they make referrals to things like mental health and substance use disorder for not only the child, but also for the family. The transportation is handled. And through our grant program, that's where a lot of those funds and resources come for the families. For example, and you asked about diversity and larger counties. So the truancy court in Prince George's County, for example, one of the great services that they provide for their truancy initiative is they have a bilingual case manager that helps with the family and the students and the courts and all the resources. So it's actually a great resource for that population. That was funded through the Administrative Office of the Courts several years ago and has been expanded. They actually have taken that to other parts of their problem-solving courts, realizing how effective that has been to get that population referred to and engaged in the resources. But we really look at, this is a whole, look at the whole family, all the reasons why they would come into, come this far into the interventions.
So this is really helpful. And I just kind of want to put in there that I appreciate that this is, an attempt to help solve, the underlying challenges that a family might be facing in getting their children to school. But I just wonder why it has to be through the courts. Like, why can't we work more with the school social workers, the school counselors? Like, why does it have to escalate and bring children into the system for them to get these interventions when, maybe there are, closer to the school options that could be potentially a better fit versus getting them to the courts. And so I think that's kind of where I'm struggling right now, but I really appreciate the work you're doing and I appreciate you coming to answer our questions. So thank you.
May I respond?
Yes, you may. That's fine, Mr. Burke. Yes.
Okay, thank you. Accountability. To answer your question is accountability, not for the students and the parents as much as it is for the other resources that help them. That's the one thing I can say for all our problem-solving courts, but truancy courts are really at the forefront, is the accountability that court, the judge or the magistrate, ensures that these services are being provided in a timely manner and really benefit the families that are involved here. The accountability is it.
May I just briefly comment on Delegate Shetty's question?
Yes, that's fine, Ms. Williams.
Thank you. I just wanted to also respond to the data. I mean, there is a concern that there isn't enough data to show the efficacy. I know, going back to Delegate Crutchfield's point, in terms of the actual court involvement, the expansion of the pilot program that Mr. Parton is speaking to. But there was a report that was released on problem solving courts through the Maryland Judiciary in November of 2021. And that actually shows that in Prince George's County, only one of the 54 participants actually graduated. So that's actually pretty startling data for that particular jurisdiction. I will also note that in the report that was provided to the committee that was discussed last time, the 2011 report, it does talk about how many of these children are from lower income communities and counties. And so that is also a concern in terms of their ability to get to court, to actually participate in a lot of the services that would be mandated through a court order. The other point I just want to note is that a lot of these kids are actually already involved in the court system. It does note that many of these children have misdemeanor offenses that have already brought them in. And so there are accessible services for many of these kids, whether it's through DSS or DJS, collaterally through any other particular context that they might have. So I just want to make sure that is stated, because there's all these other overlapping issues, but to get to truancy, it's important to look outside of the court system.
Okay, thank you very much, Ms. Williams. Delegate Lopez, I think you have a question.
Sure. Thank you, Chair Crutchfield. My question was largely answered with Delegate Shetty's last question, but this is my first time really looking at the truancy court and looking at this pilot program. And Delegate Shetty kind of raised the same questions that have been on my mind, which is this even the right course of action, and how do the resources line up? There needs to be alternatives for kids. If someone's not attending school, there's a lot of reasons that could exceed what they can do as a child. And so the information that Ms. Williams just shared with us was really telling about the number of graduates from the program in Prince George's County. It doesn't sound like that data is available from Montgomery County, but I would assume it's somewhat analogous or close enough to be a trend.
So Montgomery County doesn't have a truancy court, but actually state's attorney through their office is doing some kind of truancy. I can't even explain it to you, Delegate Lopez, because I'm not even quite clear on it. I know that I've talked to the state's attorney before, and he's mentioned he has a program where the state's attorneys in some way, I don't know if they just deal directly with high schools in particular, but maybe we can get a little bit more information on that, even just to understand what are we really dealing with. And that's my concern in all the counties. I mean, it sounds like, it's an ongoing situation in the First Circuit. And it sounds like, Judge Kent is really involved in doing the right things, but I'm just wondering what that does again for the other counties, and I think Delegate Shetty and Lopez are right in that, how does the data look other larger jurisdictions? What are they doing? And how are programs intertwined to make sure that kids are successful moving forward? So with that, I'll go to Delegate Cham.
Thank you, Madam Chair. So I have a question for the panel. I'm not sure who could answer this for me. My background is in working with children with special needs. Prior to my second life as now a politician, but my heart is always close to children with disabilities and who have IEPs. Is there any considerations in this proposed legislation that if we find students with an IEP are falling in this pit of truancy and not attending school, what does the bill speak to that, or does the child's IEP kind of takes precedence over the law? I'm not sure if I'm asking the question appropriately, but I hope you're following me.
I will attempt.
I should just say, I apologize for being late. I had trouble getting in. My name is Sarah Kaplan. I'm an attorney at the judiciary. I work on juvenile related issues and working with Mr. Barton on this program. So the child IEP would be one of the factors the court and the court staff would be looking at in the work that they do. So you have a child with an IEP, you're not going to be asking the same sort of tasks, perhaps, of the child. You're going to take that into account as you would in crafting any kind of services for the child. So it would not be ignored if the child was brought. Again, it's the schools who bring the cases in. So not saying those cases will come or won't come, but if they did come, those would be factors that would be taken into account by the court. They wouldn't be ignored.
Okay. All right. Thank
so
you.
Delegate Cham, are you thinking sort of like, if a kid has an IEP, what are they doing to make that child successful going forward? Is that what you're kind of thinking?
Right, exactly.
Okay.
Because the IEP affords that opportunity to look at new interventions, kind of think outside of the box, to help that child re-engage in the school environment. So the IEP kind of gives some liberties with what supports would that child need to be able to successfully re-engage in the school setting.
Right, and I would think that would probably go to some of the programs. What do they have, to help that child be successful? It sounds like, or it looks like, Ms. Williams, did you want to make a comment?
Well, yeah, and I think that's an excellent question and point raised in terms of kids that have IEPs. I can say that my experience working with, I did the volunteer program with the truancy through the University of Baltimore. And I noticed that a lot of those kids, when I did volunteer, did have IEPs. They were kids that, got frustrated with certain subjects and certain classes. They were just so far behind that they just didn't feel the need that they needed to go because they just didn't get it and they didn't understand. And I will say that a lot of kids that I represented through the juvenile court system, as well as the youthful defendant unit, a lot of kids that get involved in the system have extensive IEP issues that have not been addressed properly through the school system, and they seem to be falling through the cracks. And so I do think that actually a focus on providing appropriate services that are required under their IEP, mental health issues, behavioral issues, if there's a greater focus on that through the school system, that actually would probably help a lot of the truancy issues that the state is facing with these kids.
Okay, thank you. And Mr. Barton, did you have a comment?
Yeah, just and I think that's a great assessment, and you're right. There are a lot of individuals with IEPs that are in our truancy courts, and I think what's important is, again, they're assessed and screened to see what those needs are. They're also, to go back to the accountability part, where the court can ensure that the schools are actually doing what they need to do, and actually the collaboration with our school systems and with the truancy courts are very tight. If you go to the First Circuit in particular, Prince George County as well, they have a great collaboration because they feel like this is a way that they can kind of bundle all the resources they have for education and other things, as well as the courts, provide those case managers that, that their job is truancy courts. Their job is to facilitate these kids and their families through the system.
Okay. Are there any other questions for our guests? Okay, I don't see any. So what I think we'll do is we're going to hold this bill and just get a little bit more information. It sounds like we really kind of want to make sure we understand clearly what this is all about. So I do appreciate everybody coming today to help us out with our questions. And again, we will take this up on at another meeting time. Again, thank you.
Thank you.
Mhm. Okay, so I think what we'll do is we'll move on to HB 948 next. And that is Delegate Shoemaker's bill.
Okay.
So if we'll bring him in, and I think he's the only one on this bill, if I'm not
Correct.
mistaken. Okay. Hey there, Delegate Shoemaker, you're back. All right, so would you do us a kind favor? Would you just, describe to us what your bill is doing?
Okay, all it does is this.
Uh-huh.
It says that if you are on the, if you are a convicted sex offender or if you're on the sex offender registry,
Mhm.
you cannot provide informal childcare because evidently there's a loophole in the law about informal childcare. They can't work in a daycare center or something like that under existing law. But you can't even provide informal childcare, which is defined in the law as like 20 hours a month or something like that, without getting written permission, disclosing that fact that you're a convicted sex offender to the parents or guardians. That's essentially all it does.
Okay. All right. So when I think of informal, I'm thinking like my neighbor, next door, like
Right.
needs to drop their child off real quick, they
Right.
need to go someplace to a grocery store or whatever. Okay.
Right. That's all it does. And it arose out of a situation in Carroll County, as I talked about during the bill hearing, where a lady who was on the sex offender registry was providing informal childcare for a neighbor, like you alluded to, for a period of over a year before the mother of the infant discovered that this particular individual was on the sex offender registry. And that's what, raised the issue. And, I think the mother was a Latinx lady, and she found out, a year later, and she was outraged about it.
Okay. But that person was on the sex offenders register, was a registered.
Correct.
Okay.
Yes, ma'am.
Okay. All right. We'll kick off the questions with Delegate Lopez.
Sure. I got one quick question. It doesn't look like there's any bipartisan co-sponsors.
I can answer that. I had to drop it right before the drop deadline, and we had like a blue book bonanza type thing on the Republican side that we do every year. So it was sitting out for those folks to sign on to, but I didn't see any of you good folks to try to coax any of you off.
I didn't get my invite to the Blue Book Bonanza this year.
Yeah, that's tragic.
I'll keep my eyes on my inbox for the
Yeah,
next
you'll
go
have to do
round.
that. No,
My
if we'd have
friends from the
been,
minority caucus
if-
want to
if-
invite me.
yeah, if we'd always love to have you, by the way. But if we'd have been in a situation in that month prior to us being back down here on a regular basis, live and in person, then I'd have been in a position to try to get some Democratic co-sponsors, but I wasn't. So
Okay, no, I understand. With co-sponsors, like you just never know if it's like circumstantial and serendipity that you run into someone at the time when you've got your blue back and that type of thing. So I just wanted to ask. And then the other thing that, I am a new parent several times over as of recent. And
we had one. I stopped at one. So
very, very smart of you.
yeah.
One of the ways people get informal childcare is through apps like care.com, where you're connected with caretakers who might have some modicum of training, like a CPR for children, accreditation.
I didn't know that was a thing.
That is a thing. So I'm wondering, what impact would this bill possibly have on them in terms of like liabilities? Because I'm pretty sure it's like you get a premium membership and then you can screen people based on criminal background checks and do a more in-depth search versus, with the free account, you can just look at profiles and connect that way. So it might.
Well, if that's the case, it would make it a lot easier for folks to discern the nature of the person, I guess, that's providing the babysitting, services. But, this is like an unfortunate incident that called my attention to this. This lady, she didn't use an app. She went to a neighbor and, I guess she didn't know to check the sex offender registry on her own, and she learned about it a year later. So, hopefully this would curtail that type of situation.
Gotcha. Thank you.
Absolutely.
All right, and Delegate Howe, you have a question? Oh, you need to unmute yourself.
Sorry, I'm sorry.
No problem.
I have a quick question.
Yes,
What
ma'am.
about how does this relate to your family? If you're taking care of a family member and suppose something happens, does this relate to family members too?
Well, it could, under the way it's written, if that family member is on the sex offender registry, then, all that would have to happen in that regard, though, is, if the parent or guardian of the particular child was, in their own judgment, not particularly concerned about the fact that this family member was on the sex offender registry or was a convicted sex offender, then, just sign a piece of paper. And they could provide the informal childcare on the strength of that if they wanted to. So, that would fall within the category of informal childcare.
Okay, so if something happened while this sex offender had your child, that would be against the law and against this.
Well, if they didn't disclose, if they didn't disclose and provide that information in writing to the people that they were providing the child care services for, that would be against the law under the language of this bill.
Okay.
Yes, ma'am.
Thank you.
All right, and Delegate Shetty?
Thank you. Thank you, Delegate Shoemaker, for this bill. Got a lot of parents here, myself included. So I think about childcare issues a lot and do a lot of due diligence of my own because I serve on this committee and I feel like we hear every horrible case as a result. So I guess one, I'm really sorry to hear about your constituent who shared what happened to her and her feelings on it. And it sounds like she felt like she might have been deceived by not knowing this information.
Exactly.
So I understand the impetus for why you felt a need to respond with this bill, and I get it. So I guess a couple questions about the bill. I don't have the language in front of me, so if you'll just indulge me. One, what is the penalty as drafted for not complying? And is the act of not complying the lack of disclosure for the person or the lack of signing if you hire the person? And then, or does it kick in? And at what point, I guess, does the compliance component and enforcement potentially kick in? Is it if and when, the most unfortunate, horrible situation happens, then it becomes an issue. So it's like an enhanced penalty because you didn't disclose to the person, or is it, is there some other time in which, so under like the scenario that your constituent brought to you, then she could have brought action because it was never disclosed and she had hired this person, despite the sexual offender registry being public information. So kind of, if you could just break down how this bill actually would operate if enacted currently as written, I would appreciate that. And then my very related question, and it sort of builds on what Delegate Lopez was asking, I often get, babysitters from neighborhood listservs, and, it's off or word of mouth from other neighbors who use, sitters in our community that they like and they respect and that they've done well with the kids. And, so then is there like added liability for somebody who, like say I post on my mom's listserv, I didn't know, or maybe I do, or whatever, that that somebody I had hired has this type of past. Do I carry liability for sharing that they should, they should consider hiring this person because, they're really great with kids and maybe their circumstance was a conviction that's unrelated to children. So like the example that Delegate McComas gave of a prior client of hers of who had groped somebody in a supermarket, unrelated to kids, but, they happen to be really good with kids as a hypothetical situation. So sorry, I know there's like many layers of questions there.
You're good,
Yeah,
Delegate.
but I am confident that my simple country lawyer friend can handle it.
Well, let me address the penalty part
Sure.
of your litany of questions first, I guess. So under the penalty part, the existing penalties regarding registrants who knowingly enter onto property on which child care is being provided are made applicable to the provisions of this particular bill. And if you ask, the follow-up question, well, what are they? I'll tell you. It says that in the fiscal note, it says a registrant, and this is already on the books, a registrant may not knowingly enter onto real property that is used for public or non-public elementary or secondary education, or on which a registered family child care home, a licensed child care home or child care institution is located, and the violator is guilty of a misdemeanor and subject to maximum penalties of 5 years and or a $5,000 fine under existing law. So that's and we don't try to increase those penalties. We adopt the penalties already provided for under existing law.
Okay, and that would kick in when the person fails to disclose?
Well, yeah, it could. I mean, conceivably, I guess. Obviously, somebody would be able to be charged with that if some unfortunate, terrible thing happened to a kid in the sex offender's care. But I guess it could happen under either of those scenarios.
Okay.
Under the language of this bill.
So my question then that's very related here is I guess I fail to understand how an individual disclosure of this variety, I guess it sort of removes some barrier potentially, it sounds like, for some who don't know that they can look into this public database. And
it's got to be written too, by the way, written permission under.
Oh, they have to get like consent.
Yes.
Basically like an
Yes.
acknowledgement, like.
So conceivably they could still do it, provided that they get written authorization.
Got it.
From the parent or guardian.
Okay.
Hey, by the way, I'm on the sex offender registry. You just need to give me written permission to perform these services.
It's sort of like a waiver almost.
Right. Almost. Yeah, exactly.
Okay. Thank you. That's very helpful. Thank you.
Good. Thank you.
So either Claire or Lauren, I probably need a little bit of help. So I know under Chapter 11, subtitle, 7, I guess it's 11-722 of the criminal procedure article where we talk about registrants for sex offenses, that I also wanted to add in that it states that they may not knowingly, as Delegate Shoemaker mentioned, knowingly enter onto real property that is used for public or non-public elementary or secondary education, or, and that's number 1, or 2, on which a registered family child care home, a licensed child care home, child care institution, or a home used for informal child care is located. So what I guess I'm thinking, okay, so that's correct, right, Claire?
Yes, that's the statute that the bill is amending.
Okay.
The bill's adding a subsection D to that statute.
Gotcha. Okay, that's what I was trying to understand because, okay. So even though, okay, so they're already restricted from entering into a home where informal childcare is occurring. But
they are precluded from rendering the care. That's the strange thing about it. That's what I'm seeking to address here. Oh, by the way, Madam Chair, I think that Delegate Cardin had an amendment that he was suggesting. I thought that touched on removing the part dealing with 4th-degree sex offenders. I don't know.
Okay, I haven't seen that amendment.
Okay.
I don't think council has either.
Okay.
So, or
I thought he did, but I could be wrong. I've been wrong.
Yes, yes, I did see that, and I to your staff, or I sent it to Delegate Crutchfield.
Oh, okay. So you did send it to my staff. Okay, I haven't seen it. Let me find it then.
That might address the concerns that some people had about the groping situation or whatever, that, you know, they're a 4th-degree sex offender, and that's the nature of the underlying offense. So,
okay. Claire, are you able to resend it to us? Okay. Okay, so, all right. So
I will. It'll take a moment to find it.
No problem. I guess what I'm trying to understand is in these other situations, it just looks like, again, a person that's registered. I mean, if we're saying all this says is that you can't enter the property, then is there anywhere, I guess, in the statute where it really talks about whether you can, or it goes into, I guess, the real restriction on you cannot be an employee, for example, or you can't, I mean, is there, and I don't know where that is. So I probably need a little bit more study on that piece, Delegate Shoemaker, unless you do know. Do you know that statute very well? Because I certainly don't.
No, I don't. All I know is that the sheriff's office in Carroll County looked into the situation that I relayed earlier that prompted this bill.
Okay.
And so did the state's attorney's office up there. And they made a determination that under existing law, nothing could be done about it.
Okay, gotcha. All right. Delegate Lopez, you have another question?
I do. And after being on this committee so long, these are things I should probably know by now. But when someone is a registered sex offender, is there anything that's denoted if the crime involved a minor? I guess maybe that's the best way to put it. Or is it just like, it's kind of how it's all, once you're on the registry, you're on the registry.
Right. So anything to denote that.
Yeah.
Well, it's complicated. It's you would have to look, if you look on a sex offender registry, it tells the crime that the person is on the registry for.
Mm-hmm.
So, and there's supposed to be a plain language description of the crime. But basically you would have to look at the statute, and even by looking at the statute, you might not be able to figure it out, because it just would depend on the circumstances of the crime. You might have to go to the courthouse and look in the file. But like if it was child sex, if they were convicted of child sex abuse, then that would be obvious. But in some cases, it might not be obvious. But everybody is just, there's 3 tiers, depending on the severity of the offense, tier 1, tier 2, and tier 3. And there's the victims, the type of victim is all mixed in.
One tier can, I think, will require you to be on there forever or whatever. And there's another tier for like 30 years. And there's
25.
Another tier for, oh, is it 25? And another for
15,
or
25 in life.
That's it. Yeah, that's right.
Gotcha. Okay, this is all making sense now, because I remember this in previous years when we talked about the sex offender registry. I was like, I don't quite remember all the details. And then maybe as a follow-up for Claire, when someone has to disclose that they're on the registry, what is actually a requirement of them? Like, it doesn't need to be in writing, it's an oral, but like, what's the information that they need to provide to someone?
Well, there's no requirement in chapter, in the criminal procedure article, the subtitle on the sex offender registry. There's nothing in there that requires a registrant to disclose to anybody in a particular situation that they're on the registry. They have to register with at periodic intervals depending on your tier, and you do that at the police station, and the Department of Public Safety maintains the registry, and you have to keep them updated. Like if you move, you're supposed to let the registry know immediately of your new address. But in that subtitle, there's no requirement that, hey, if you get a job, with your employer.
Okay.
And the reason, if I could follow up just for a second, I mean, in the reason why I said, or why the bill is crafted in such a way as to require written permission, it's because there are situations, I'm sure, in which it might be a close family member who made a mistake, and the parents recognize that, and they're not at all concerned about this particular friend or family member or whatever the case may be, in providing informal childcare for their child. But out of an abundance of caution, it seems to me they ought to just get the written permission instead of having an outright blanket prohibition. So that's I was trying to hit a middle ground there with that.
Okay.
Gotcha. Thank you.
Right. Any other questions anybody else have? Okay. Well, I really think that we probably need some more time on this one to just make sure we understand completely how this works and make sure we understand the statute as well. So, but I do appreciate it very much, Delegate Shoemaker, you coming and you presenting for us.
My pleasure.
All right.
Thank you all.
All right. Thanks again. Don't worry, we'll be back in touch.
Yeah. Okay. Thanks.
On this one. All right. Thank you.
Bye-bye.
Bye. All right. So we're going to next go to HB 83. And we will let Delegate Shetty lead on this. And I'm not sure if Chair Atterbury will join us or not, but I know that she had a voting session, so she may or may not. So I will turn it over to you, Delegate Shetty, as soon as your guests come in. And I think they are now coming in. Okay.
They are. Thank
Yes.
you, Madam Chair, and thank you, colleagues, for considering this bill as well as the amendments that I'm bringing before you today. So as you'll recall, the base bill is Delegate Chair Atterbury's 7th year attempt at addressing child marriage here in Maryland. Many of you have probably seen some of the articles and things that have been written about this fight, and many of you have voted on various versions of this bill that have been brought before this committee. And so I bring before you today an amendment for your consideration that seeks to strike a balance at addressing some of the concerns that that we all share, while also trying to hopefully move this bill a little bit closer to the finish line here in the General Assembly. So I'll start by saying that the general bill as amended would lower the age of Maryland here, or it would raise the minimum age of Maryland rather to 17, whether or not you're pregnant. And what it does is it maintains the originally proposed judicial review, which allows or requires the young people to appear before a judge so that the independent person could assess whether there's any duress or coercion involved. It also seeks to, so you may recall a prolonged discussion we have had over the years around the requirement of emancipation before the young person gets married. And in part, that was the policy idea that's been brought before us to ensure that should the young person decide that they no longer wish to be in the marriage, because they are a minor, they don't have the capacity to get out of the marriage without their parents' consent. They also don't have the capacity to contract. So in the hypothetical scenario in which a young person is married and they wish to get out of the marriage and they don't have the consent of their parents to get out, where will they live? So what the amendment does is it only allows for grants like a limited emancipation for both the purpose of divorce as well as to contract. And so this again addresses the scenario in which a 17-year-old who is still a minor seeks to exit a marriage. They would be able to do so under this amendment, and they would have an ability to contract for a lease so that they could have a place to live after that decision. Those are the main changes that have been made with these amendments, I believe. But I want to also note that the base bill also includes a 4-year age gap requirement, and that remains unchanged under the amendments proposed to you today. I personally believe that that's an important provision to continue to include. And so I am not messing with that part intentionally. So I welcome any questions as well as any, I know we have Casey and Alex here from the, I'm going to mispronounce it, but they are our prime advocates here who have been working hard on this issue alongside of Chair Atterbury for the last 7 years. And they represent a number of young women who have been impacted by our existing laws today. So thank you, colleagues, for your consideration, and I look forward to your questions.
Great. Thank you so much, Delegate Shetty, for bringing this bill to us and making sure we understand the amendments, because the amendments are really important. So, I have a really quick question, and I'm trying to understand how a limited emancipation would work. You mentioned that the young person would go before a judge, to determine and make sure there was no duress or any other factors involved in making a decision to get married. Mm-hmm. And at that same time, once that judge makes a decision, would they then say to that individual, this is what, this is now your right to a limited, emancipation?
So there is no requirement of emancipation any longer for the purpose of marriage. It is, if you are emancipated, then you certainly can get married without parental consent. What this does is it says you are not required to be emancipated for the purpose of marriage. So you still require parental consent if you're 17 and not emancipated. Correct, Alex and Casey? No. Yes.
Very, very close. No. I think what we landed on was the phrase limited emancipation. Alex and I agreed didn't really make a whole lot of sense in the context of Maryland. And so as Delegate Shetty just shared, it's now shifted to if the judge approves the petition for a minor to marry, that minor is then authorized to sign contracts and seek divorce. And part of the bill includes, in the process of going before that judge, the judge is required to give you information about your rights. And that information packet would include an explanation of, as a married minor, now you're allowed to do X, Y, Z. And the parental consent piece, we landed on parental consent is important in the judicial review process. And if any parent, either one, objects to the marriage, the judge, that's a rebuttable presumption to say that this marriage should not go forward. Parental consent is not the only requirement for a judge to consider approving a minor for marriage. It's part of the package. And we really empower the parents here to be the ones to protect versus the ones to just sort of rubber stamp a marriage that a minor might not want.
Okay. And so with that court authorization, are they given like some kind of written document that indicates now that they can, make contracts, make binding contracts, divorce, et cetera? Because I mean, I can imagine maybe maybe there is a minor at some point, maybe they're 17 and a half, decide, I don't want to be in this anymore. Don't necessarily get the divorce right away and need to leave. So they would have something, I'm assuming, to document that they can actually make binding contracts. And those contracts that they can make binding, are they limited contracts? Are they just for the ability to, take care of yourself, house, car, whatever? Can you tell us a little bit more about that as well?
I don't believe that the contractual side is limited, right? Yeah.
Okay.
But it is essentially for those purposes.
Okay.
It's granting those abilities so that the minor would have the ability to take care of themselves.
Okay. Anybody have any other questions? Okay. So, and then, okay, go ahead, Delegate Lopez.
Oh, no, I was just going to say, I want to commend Delegate Shetty and the advocates for a lot of work to get to this place with amendments, because I know after 7 years of working on anything, it's going to be complicated. And this seems to be like you've thread the needle as much as anyone possibly could on this. So congratulations on arriving at some amendments.
Thank you. And I want to just add that, Chair Atterbury has been working so hard on this, along with Senator Alfreth. And this is a really, really important issue here in Maryland. And so I'm really grateful for their leadership.
And I have one more question, and that is about the 4-year age gap. Can you tell us a little bit about that and how that really works?
Yeah, so thank you, Madam Chair. Under existing statutory rape laws here in Maryland, you cannot engage in sex with a minor if they're more than 4 years your junior. And so the original provision of the law, the original bill is introduced mirrors that 4-year age gap requirement. And so we have maintained that under the existing bill. We have not touched that provision.
Okay.
So 17-year-old can get married under this proposed bill. There's a 4-year age gap imposed.
Right. Okay. Great. And do you know what the current posture of the bill is in the Senate side? Has it been passed with the same amendments or?
No, so thank you. That's a great question. JPR did amend the bill. Some of the amendments that I proposed to you today mirror those, and some of them do not. But I believe that the bill as amended, if adopted, adopts a number of really important provisions that JPR felt very strongly about and passed. And I believe that their bill passed out of the Senate chamber as well, as they had amended it. And then there are some differences still between the two.
Okay.
Gotcha.
Okay,
A question.
sure.
I remember reading somewhere, but I'm not sure. What is the lowest age? Like a 17-year-old could not be with a 13-year-old, correct?
So you're talking about, yeah, right, because the age of consent is 16 in
16.
Maryland.
Okay,
Right,
I just wanted to make sure I did see that somewhere.
right. Yes, you're correct.
Okay.
Yes.
Any other questions that we have? Okay. All right.
Can I move my amendment?
Yes, you can move your amendment. Delegate
Move
Shetty.
my amendment, please.
Anyone second?
Second.
All right, great. All right, let's just do a quick hand count on the amendment. Everybody in favor of the amendment, raise your hands. Okay, 1, 2, 3, 4. Oh, Delegate Munez, of course, it's gone, unfortunately, but that's still okay. We've got 5. Okay. All right. Okay. Do we want to move on the bill?
So moved.
Okay.
Second.
Second. Okay. All right. I wish Delegate Munez was here so she could at least vote, but we'll, let her.
Do you want to do a roll call so that we can like
Yes,
delay
I
just a
am
little
going
bit?
Yeah, I am going to do a roll call. I was just writing it down, so I just had everybody's names and everything. All right, so I'm going to do it by screen. So Delegate Shetty.
Yes.
Okay. Delegate Lopez.
Yes.
Okay. Delegate Cham.
Just a point of clarity, I apologize, Madam Chair. To understand,
Yes, go
we
ahead.
are raising the age from 16 to 17.
I will let Delegate Shetty explain again.
Yes,
Go
please,
ahead.
please, if you don't mind, Delegate.
Yes, ma'am. Yes, we are the minimum age of marriage would be 17. If
Thank
this
you.
bill passes, yes.
Thank you.
Yes.
Yes.
Okay. Delegate Howe.
Yes, I would like to vote for that. I'm just slowing it down, but I'll say Delegate Munoz. Yes.
And I'm a yes, and we will just have to wait to see what Delegate Munez wants to do. So even without her vote, it's a favorable out of the subcommittee, okay? With the amendment. Okay, and any other questions, any other just discussion on your vote or anything like that? Anybody have?
Just unrelated to the bill,
Sure.
are there any men assigned to this subcommittee?
You know what? It's really funny, but no.
I feel like that's gonna change some things.
I know, you know what? It was funny because I noticed that last time. I was like, wait a minute. But that is correct. No, they're not.
I'm not trying to nominate anybody, but
Yeah, I know. I
think
get
we're fine
it.
just as we
I
are.
get it.
But
I
it
get
just
it.
had to
But
be
yes,
noted.
yes, it is noted. Well, I think that's it for us. And, unfortunately, we don't have Delegate Munez, but okay. So anyway, I appreciate everybody being here. Thank you so much to our guests. And how do you pronounce the organization that you, Casey and Alex, are with?
Committee still going.
Tahare, like you're cheering. Tahare.
Tahare. Okay. Thank you so much. We do appreciate you being here.
Thank you.
And that ends our subcommittee for today. Thank you very much. And we will be back probably sometime next week. Thanks again. All right. Oh my goodness, Delegate Williams. We've already, but I feel bad,
I'm so sorry, Madam Chair. I had 2 bill hearings in HGO that started roughly at the same time as subcommittee started. And I'm so sorry. I came in as soon as I could.
No problem. We just had one bill that we voted on, and that's HB 83.
Okay.
And I don't know, Delegate Shetty, you want to just quickly, because we can still let you vote.
Okay, sure. Yeah, maybe that'll give Delegate Munoz some opportunity to come back if she wants as well. Right. So I offered an amendment that you have received, Delegate Williams, as well as an interlineated copy of the bill. But what it does is it adopts some changes that JPR included as part of their bill that passed the Senate, but seeks to strike a balance and move this bill a little bit closer to the finish line. It has been a 7-year Herculean effort by Chair Atterbury and the advocates here today. But what the amendment would do is it would make the minimum age of minimum age of marriage in Maryland 17, regardless of whether you're pregnant or not, but it maintains the judicial review component so that a judge has an opportunity to assess whether there's any coercion or duress involved. What it also does is it ensures that the young person, while they are not required to be fully emancipated at marriage, it would give them the ability to contract as well as the ability to exit the marriage in the event that that's needed. And it maintains the 4-year age gap provision that was in the original bills as introduced.
Well, that sounds like really great amendments. I think it's a healthy compromise. I would love to see full emancipation, but I understand we're also trying to strike a balance here. And so if that was the bill that we're voting in favor of, then I vote yay in favor of the
Perfect.
bill.
Great. All right. Then it sounds good. Well, thank you very much for everybody attending again, and definitely our guests who gave us great information on the bill. And Delegate Shetty, thank you for your bill presentation. And that ends our day. Oh, Delegate Munez, you're back. So we just voted on HB 83. And Delegate Williams just came on board and gave us her vote. So we'd love to have your vote as well on the bill. Did you have any other questions about the bill?
No, I apologize. Anyone who's been pregnant on here might understand random pregnancy nosebleeds. So I'm sorry I had to walk away.
Oh no. Sorry to hear that.
I apologize.
Yeah. Well, we just voted so I'll let delegates if you'll explain where we are with everything.
Sure. Yeah, no problem.
One more time. That's it.
One more time. All right. Hopefully I get it right this time. So thank you. I hope you're doing okay, Delegate Munoz. I don't know if you were here for when I explained the amendment earlier, or if you had to exit at that point, but what the amendments that I offered do is it makes the minimum age of marriage in Maryland 17, regardless of whether you're pregnant or not, but restores the judicial review component, which was part of the original bills as introduced. That allows for a judge to assess whether there's any duress or coercion occurring. And then once the parties are granted the ability to get married, they are also given the limited ability to divorce if they choose to pursue that path, and they also are given the ability to contract so that they have the ability to take care of themselves, sign a lease, get a bank account, etc. Then it maintains the original bill's 4-year age gap requirement, mirroring our statutory rape laws here in Maryland. So those are what the amendments do, and I would respectfully request your vote. Thank you.
Okay, and we've all voted, and we have all voted affirmatively in favor of the bill as is with the amendments, and would love to just have your vote as well, so we can.
Okay, just mark me down. Yes for the amendment. Yes for the bill, please.
Okay, perfect.
Thanks so much.
Well, thank you.
Sorry about that.
All right, everybody, have a good weekend. Thanks.